Welcome to the online information seminar on the changes to the Construction Contracts Act 2004. From the 15th of December 2016, important changes to the Construction Contracts Act, or the CCA, commence operation. These are the biggest changes since the CCA first commenced operation in 2005. The broad scope of the construction contracts that the CCA covers means it's important that all participants in the building and construction industry are aware of the changes. This includes contractors, subcontractors, suppliers, consultants, and any individuals or organisations who enter into contracts for construction work, including contracts for design, build, maintenance, and services such as plumbing, electrical, fabrication, and earthworks. This online seminar covers 4 key areas. Firstly, what is the CCA and what it does? Secondly, a brief background on the changes and the policy drivers behind them. This context is important in understanding why the Act is changing and the future changes that may be made. The seminar will then cover the key changes to the CCA, and finally, it will have a quick look at the possible future changes. The CCA is a very important piece of legislation for anyone in WA's building and construction industry. Broadly, it does 3 key things. Firstly, it prohibits payment provisions in construction contracts that slow up the movement of cash through contracting chains. Secondly, it implies fair and reasonable payment terms into contracts that are not entirely in writing or lack certain provisions. And finally, it provides an effective, rapid adjudication process for resolving payment disputes. The rapid adjudication process under the CCA is known as a pay now, argue later system. This means payment disputes under construction contracts are determined by an independent adjudicator. The decision of the adjudicator is then binding on the parties and payment must be made on account. If the parties wish to litigate or arbitrate the dispute, they still retain their full rights to do so. The adjudication process is designed to keep cash flowing in the contracting chain and is unique to the construction industry. The adjudication scheme under the CCA is actually unique to WA and differs from similar legislation in New South Wales, Victoria, Queensland, South Australia, Tasmania, and the ACT. The key differences between the CCA and legislation in other states and territories are firstly that it preserves the payment terms in contracts rather than creating a separate statutory right to progress payments. Secondly, it allows for the adjudication of payment disputes up and down the contracting chain, so a head contractor or principal can make an application for adjudication where there has been a failure by a subcontractor to perform obligations and thus a payment dispute has arose. The CCA was passed by the Parliament in 2004 and commenced operation in 2005. Since commencing operation in 2005, there have been almost 1,700 applications for adjudication, and the total value of payment claims disputed is now over $2.7 billion. Why is the CCA changing? Well, in 2013, the Small Business Commissioner, Mr. David Eaton, completed an investigation into payment issues for subcontractors on the Building the Education Revolution construction projects between 2008 and 2012. Among the many recommendations made by the Small Business Commissioner was the need to review the CCA. In mid-2014, the state government appointed Professor Philip Evans from Notre Dame University to conduct the statutory review. Professor Evans completed an extensive review in August 2015 and provided a report to the state government for consideration. The review of the CCA found that in the 10 years of operation, it had been working well for the industry. However, Professor Evans made a number of recommendations for improving the operation of the Act and the adjudication process. In August 2016, the state government announced a package of measures to address payment issues in the building and construction industry, and this included adopting the majority of recommendations from the review as well as other comprehensive reforms. In September 2016, the state government introduced the Construction Contracts Amendment Bill 2016 into the Parliament. This bill contained the first package of amendments the government intends to make to the CCA. The bill passed the Parliament on the 22nd of November, receiving royal assent on the 29th and becoming the Construction Contracts Amendment Act 2016. The majority of the changes contained in the Construction Contracts Amendment Act 2016 will now commence operation from the 15th of December 2016. Broadly, there are 8 key changes to the CCA, which we will now look at over the next slides. One of the more significant changes is the way in which time is computed under the CCA. It is extremely important to be aware that the majority of time limits contained within the CCA are now expressed in business days, not calendar days. The only expression of time in the CCA that remains measured in calendar days are those in Section 10 and the implied terms contained in Schedule 1. The term business day is defined in Section 3 of the CCA to be any day other than a Saturday, Sunday, public holiday, or day between 25 December and 7 January. Principally, the change to expressing time in business days is about addressing the annual difficulty where the time for preparing a response or determination falls over the Christmas and New Year period, which is a traditional industry shutdown period. In the next slide, we'll look at an example of how the change works. The example used will be where the application for adjudication is served on the respondent on 16 December 2016. The example will then compare the time limit for preparing and serving a response under the previous 14 calendar day limit and the new 10 business day limit in Section 27(1) of the CCA. Under the previous time limit in Section 27(1) of the CCA, if the respondent was served with an application for adjudication on the 16th of December 2016, they would have a maximum of 14 calendar days in which to prepare and serve a response. This 14 calendar day time limit would commence running from 17 December 2016 and end on 30 December 2016 when the respondent would need to have served the response. As you can see from this example, the last day for preparing and serving the response falls in the week between Christmas and New Year. If we now look at the same example, but with the change to Section 27(1) of the CCA in operation, the respondent will have 10 business days from being served with the application on the 16th of December 2016 in which to then prepare and serve their response. The 10 business days will commence on the 19th of December, which is the next business day after the 16th of December, and will now end on the 13th of January 2017. By far the most significant change is to Section 26(1) of the CCA to increase the time limit for making an application for adjudication from 28 calendar days to 90 business days. This change means an application for adjudication can now be made 90 business days from when a payment dispute arises under the construction contract. It is also important to be aware of the transitional provision in Section 58 of the CCA. This transitional provision provides a limited window in which applications for adjudication that may have been time-barred prior to 15 December 2016 can be resurrected if an application can be made within the new 90 business day limit. This means an applicant can effectively look back 90 business days from the 15th of December 2016, and if a payment dispute arose under the construction contract within that period, then an application for adjudication will not be time-barred, even though prior to 15 December 2016, the 28 calendar day time limit applied. The time limits, though, for preparing a response and the default time limit for making a determination remain effectively the same, except are now expressed as 10 business days, not 14 calendar days. Another one of the significant changes to the CCA is the recognition of the process under virtually all construction contracts of payment claim recycling. Changes to the definition of payment claim and payment dispute means the CCA now provides more flexibility for applicants where a payment claim has been made under a construction contract and the payment claim includes amounts that were in a previous payment claim made at a prior stage or interval. Where the amount in a previous payment claim made under a construction contract is disputed or not paid, if that amount is claimed as part of the next payment claim under the contract and again disputed or not paid, then for the purposes of the CCA, a payment dispute will arise and an application for adjudication may be made within 90 business days. Under the majority of construction contracts, claims for payment on account are made at stages or intervals as the particular project progresses. Where an amount is claimed at one interval or stage, and the payment of the amount is not made or the amount is not certified as owing at that stage, the contract will generally allow for the same amount to be claimed at the next interval, usually along with other amounts being claimed for work completed in that next interval. Previously, the CCA operated such that when the amount was first missed or not certified, a payment dispute arose and the 28 calendar day time limit for making an application then commenced. Under the changes, if the amount is now included in another payment claim made under the contract, then a payment dispute will arise if the amount is not paid or not certified. The 90 business day time limit for making an application for adjudication will then commence. This change is designed to align the CCA more closely with the rights provided under construction contracts. However, it is important to be aware that if the amount in the payment claim has already been the subject of a determination or dismissal made by an adjudicator, then the CCA will not recognise a new payment dispute over the amount. This is intended to prevent the potential for any adjudicator shopping. Changes have been made to narrow the types of construction work excluded from the operation of the CCA. The CCA applies to all contracts for the carrying out of construction work on site in WA. Construction work has an extremely broad definition. However, there are specific types of construction work that are excluded from the definition by virtue of Section 4.3. Section 4.3 has been amended, however, to now broaden the types of construction work that the CCA applies to by narrowing the specific exclusions contained therein. The first change is a slight narrowing of Section 4.3c to specify that only the fabricating and assembling of items of plant used for the purposes of extracting oil, natural gas, or any derivative of natural gas, or any mineral-bearing substance is not construction work for the purposes of the CCA. This narrowing means that contracts for certain civil works carried out as part of building a mining plant or oil processing facility on site in WA are now captured by the CCA. The second change is the complete removal of the previous Section 4.3d exception for wholly artistic works. Principally, this change is aimed at ensuring that contracts covering art installations or sculptures that might be part of a mixed residential and commercial development or precinct are included within the operation of the CCA. Previously, the CCA did not provide a formal mechanism for withdrawing applications or for instances where the parties to the dispute reached a settlement prior to the adjudicator making a determination. This has now changed. Under Section 31(2), paragraph A, subparagraph IA, adjudicators must now dismiss an application without determining the merits where the applicant has given written notice of their wish to withdraw. Where the parties have reached settlement prior to a determination, the adjudicator now has the discretion in Section 31(2)A to issue a determination giving effect to the terms of that negotiated settlement. Both of these changes now mean that adjudicators can more adequately deal with any costs in accordance with Section 34 and 44 of the CCA. A minor change has been made to Section 31(2), Paragraph A, Subparagraph II of the CCA to clarify that an adjudicator has jurisdiction to determine a payment dispute where satisfied that there has been sufficient compliance with the requirements in Regulation 5 of the Construction Contracts Regulation 2004. Regulation 5 prescribes the particular details that must be included in an application for adjudication. The change means the adjudicator can proceed with determining the payment dispute if satisfied that the information in the application is sufficient to allow him or her to identify the parties. An important change has been made to Section 43 of the CCA to remove the requirement to obtain leave of the Court of Competent Jurisdiction to enforce an adjudication determination. While in practice the requirement to seek leave of the court was largely just an additional process, in the sense that there were few, if any, instances where the courts would refuse leave, the change makes it easier for parties who need to use the courts to enforce the determination. Section 43 of the CCA now prescribes a requirement that a party entitled to be paid an amount under a determination may enforce it by filing a certified copy with the Court of Competent Jurisdiction and an affidavit as to the amount owed. Once filed, the determination is taken to be an order of the court and may be enforced accordingly. The Court of Competent Jurisdiction for filing the determination continues to depend on the amount to be paid under the determination. The final and important change to the CCA is the amendment to Section 10, which commences operation from 3 April 2017. This change will impact any construction contracts entered into after that date. From 3 April 2017, Section 10 of the CCA will provide that any provision in a construction contract that purports to require payment to be made more than 42 days after it is claimed shall be read as requiring payment within 42 days after it is claimed. It is important to be aware that days in Section 10 will continue to be measured in calendar days, not business days, like the changes to other sections of the CCA. If a construction contract entered into after 3 April 2017 provides for a payment term greater than 42 days, for example 90 or 60 days, then for the purposes of the CCA, the parties to the contract would be in a payment dispute on the 43rd day from when the payment claim is made and not paid. This means the 90 business days to make an application will commence from that day, not the day under the terms of the contract when the payment is to be made. In anticipation of this change to the CCA, it is recommended that contractors and subcontractors begin to look at their standard form contracts and ensure that as of the 3rd of April 2017, they will comply with the requirements of Section 10 of the Act. That concludes the summary of the key changes to the CCA as a result of the Construction Contracts Amendment Act 2016 commencing operation. However, in 2017 and 2018, there is likely to be a second package of reforms to the CCA. This package of reforms will include the remaining recommendations from Professor Evans' review, as well as the other commitments of reform made by the state government in its statement on 12 August 2016. Thank you for taking the time to listen to this online seminar. If you require further information on the CCA generally or on the changes, please visit our website at www.commerce.wa.gov.au/Building Commission or contact us on 1300 489 099 or via email at cca@commerce.wa.gov.au.